Good day, Crime Talk aficionados. We have an early show for you today because, well, I got to go to a grand jury. But what do we have on the docket for you? First, the defense says they are not ready in the Bryan Kohberger, their most recent filing. No verdict yet in the Karen Reed case due to juror confusion. We have an update on the Travis Decker search and a new image released to help find him. An Illinois high school teacher indicted on 52 additional charges in a student sexual abuse case. Shocking. A $1.4 million heist of Nintendo Switches. This day in legal history, our legal quote of the day, as well as our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and yes, you can always go check us out on any of your favorite podcasting apps. Before we get to today's docket, let me remind you to go to crimetalksearch.com and sign up for that background subscription service today. You're going to be happy when you do, because you're going to be able to do as many searches as you desire, and you're going to get a report literally emailed to you that's going to have everything you want to know about the person that you're interested in finding out information about. You're going to get phone numbers, email addresses, social media presence, criminal history, property that they own. Are they married? Are they divorced? Everything you want to know, ladies and gentlemen. So go to crimetalksearch.com. You're going to be happy that you did. All right. As I said in the intro, a little bit early show today because there's a lot going on, first of all. But second of all, I have to go sit with a client in a grand jury. Now, normally in a grand jury, for the federal grand jury, if your client gets a target letter or is a witness, now the attorney has to sit outside. But in the state system, at least here, we get to go sit with our client. We can't say anything. We can just listen. And it's better to be a witness than a target. Let me assure you of that, because if you're a target, guess what? You're taking the fifth. All right. So let's go ahead and open the record for June 18th, 2025. And first, yes, the attorneys in the Bryan Kohberger matter say they are simply not ready and you can't make us go. Well, we'll find out later today when the motions hearing in the Bryan Kohberger matter begins. We'll bring it to you at 12:30. So if we get this up before that, check it out live, and we'll have updates as well as things go on. But the defense has filed a reply brief, prosecution's response, and it was filed yesterday afternoon, but we're getting it up for you today. And it's addressing the state's opposition to their motion to continue the trial. Now, the defense argues that the continuance is absolutely essential to protect Bryan Kohberger's constitutional rights and to ensure a fair trial. First, necessity for effective assistance to counsel. The defense asserts that denying a continuance risks reversible error by compromising Kohberger's Sixth Amendment right to effective assistance to counsel. They're saying that they need to do their thorough mitigation investigation required in capital cases under Strickland v. Washington and Wiggins v. Smith, and that remains incomplete due to newly identified investigative needs, i.e. the alternate suspect, which should be heard today, and we'll see hopefully how the judge is going to rule on that as well. Anyway, prior compliance with the court's scheduling order doesn't negate the need for additional time to meet the constitutional standards. As you may recall, the prosecution said, hey, they were always able to get ready for everything else in this case, and now they're not ready for trial. We don't buy it. Anyway, then they say, hey, we need more time because we're actually ahead of schedule. The defense refutes the state's claim that the case's 2.5-year duration is sufficient, noting that the federal capital cases average 3.55 years from indictment to trial. The defense cites high-profile cases like the Nicholas Cruz case, often take much longer, and the defense seeks a reasonable adjustment, not an indefinite delay, to complete essential tasks. And they say, hey, this case is complex with all these media challenges. So the Kohberger case obviously is extraordinarily complex due to the reluctant witnesses, difficulty securing experts, pervasive media coverage, and logistical barriers in multi-jurisdictional investigation. Welcome to defense work. I know his team is experienced attorneys, but you always have this problem. Witnesses won't talk with you. Experts are unwilling to agree to come testify. Maybe they'll, be an expert behind the scenes, but they don't want to testify. And yes, you usually have people in other jurisdictions or across the state. It's called dealing with it. Anyway, the defense says these factors necessitate additional time to ensure a constitutionally adequate defense. The defense also says that these prejudicial media leaks are a big problem. As you may recall, there was the recent Dateline episode and an upcoming book by James Patterson and an Amazon Prime docuseries, all containing non-public information in violation of the court's non-dissemination order, and it poses a unique prejudice. These leaks taint the jury pool and require investigation to identify sources, as they may constitute Brady material relevant to witness credibility and investigative bias. They also note that it's going to result in an inadequate jury selection timeline. The court's 2-week voir dire period is insufficient to address the impact of prejudicial media and the death penalty views in this high-profile case. Extensive individualized voir dire is needed to ensure an impartial jury, which the current schedule simply cannot accommodate. And then they cite the old ABA guidelines. These are the professional standards put out by the American Bar Association, which frankly, most people don't listen to the ABA anymore, anything, because they've just, for the most part, gone crazy. Anyway, the defense emphasizes that the ABA guidelines for the defense counsel in death penalty cases include statutorily adopted in Idaho, define prevailing professional norms for effective representations, and these guidelines underscore the need for a comprehensive mitigation investigation supporting the continuance. And they basically say victims don't care. All right. The state's reliance on the Victims' Rights Act to have a timely disposition cannot override Kohberger's fundamental rights to a fair trial and effective assistance of counsel. The state's choice to pursue the death penalty inherently extends the pretrial process, and the non-capital trial would proceed faster if the state withdraws its death penalty notice. I don't think that's going to happen. And basically, they probably could have characterized it just a little bit nicer, but basically saying, hey, victims' rights don't trump constitutional rights. They're not equal. So therefore, Judge, you got to go for the defense. So ultimately, the defense argues that the continuance is necessary to complete its constitutionally required mitigation investigation, investigate prejudicial media leaks, and to ensure a fair jury selection process. And hey, Judge, if you deny our motion, you risk of violating Kohberger's rights under the 6th, 8th, and 14th Amendment. And guess what? Potentially leading to a reversal if there is a conviction. All right, once again, ladies and gentlemen, 12:30 today. That's the start of the hearing. A lot of it will be held in chambers, as they do in Idaho. Very weird and disturbing fact that they do that. But as soon as it is public, we will bring it to you live, so make sure you join us. Next on the docket, Karen Reed. Deliberations continue. Why? Because apparently jurors are confused as to what is evidence. So Karen Reed's second murder trial on Wednesday, after there was some apparent confusion for jurors, Tuesday over guilty versus not guilty on certain charges. Court got underway today right about 9 o'clock, a couple minutes later than usual because someone involved in the trial had a minor car transportation issue. And then after briefly addressing the jury, the judge sent them back to continue their deliberations. The judge said the plan is for everyone involved to remain within 10 minutes away and to return to the court at 4 p.m. unless the court reaches a verdict before then. Now, the jury sent a total of 4 questions to the judge yesterday, and the responses that the judge gave were appropriate. Jurors asked what was the time frame they should consider for the operation of under the influence charge. Is it 12:45 a.m., right, when she was dropping everybody off when he was driving, which is when the prosecution alleged Reed's hit John O'Keefe? Or is it 5 a.m. when she drove back the next day when Reed got in her car to find O'Keefe? It's the 12:45 a.m., ladies and gentlemen. What trial were these people sitting through? Seriously. Anyway, the judge told them that they are the fact finders in this case, and it's up to them. Jurors also wanted to know if video clips from Reed's media interviews played during the trial are considered evidence and how that they should be considered. The judge said, yes, they are evidence, and they should be given whatever weight the jury deems them appropriate. So let me get this straight. This jury, I don't know if it's 1 or 12 or what, but what freaking trial were they sitting through? Evidence comes in. If it's played in court, it's evidence. It's evidence. That's why we have trials. Legal incompetent evidence. Now, they can completely disregard her admissions where she says, well, yeah, I was drunk. And, I thought I hit him, but I didn't think he was mortally wounded. You should be able to give that the weight it deserves. I've always said it's the defendant's own words that get him in the end. But how could a jury go through 30 some odd days of trial and somehow think, is that really evidence? Boom. Wow. Anyway, who knows what the jury will do? And then the third question is they want to know if convicting guilty on a subcharge like offense number 2, number 5 convicts of the overall charge. The judge responded by amending the verdict slip, something that had previously been requested by the defense, but was then denied by the judge. And then she realized, so let's help make it simple. And the last question from the jury on Tuesday indicated that there may be some disagreement amongst jurors. They asked, if we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just the 1 charge? The judge responded saying that's a theoretical question that she cannot answer. Anyway, we have the Karen Reed trial, the verdict watch up. And once it happens, obviously we'll bring it to you live. And if I'm not sitting in front of a grand jury, I will be here with you as well. Next on the docket, Travis Decker. Look at this guy. A new wanted poster has been released in the hunt for fugitive dad Travis Decker as the frantic search for the ex-soldier suspected of murdering his 3 young daughters stretched into its 3rd week. Now, police blasted out 3 photos late yesterday to show how the 32-year-old father potentially could have altered his appearance while on the run. The digitally altered images show Decker, who authorities warn is armed and dangerous, with his unusual long hair, as well as ones where he is sporting a shaved head and 0 facial hair. Now, large-scale search crews have been scouring the remote areas in Washington state since Decker failed to return his girls to his ex-wife on May 30th. The 3 sisters, Paitlin 9, Evelyn 8, and Olivia 5, were all found dead at the campground where he was with the girls last. Anyway, the United States Marshal Service is offering a reward of up to $20,000 for information that lead to his capture. And next on the docket, an Illinois high school teacher indicted on 52 additional charges in a student sexual abuse case. So let's go to DuPage County, Illinois, where an Illinois grand jury has indicted Christina Formello, a 30-year-old former teacher and soccer coach at the Downers Grove South High School, on 52 additional felony charges related to the alleged sexual assault and abuse of a 15-year-old male student. The charges announced by the DuPage County State Attorneys Robert Berlin on Tuesday included 20 counts of sexual assault, 20 counts of aggravated criminal sexual abuse, 6 counts of indecent solicitation of a child, and 6 counts of grooming. Now, the investigation began in March of 2025 when the victim and his parents reported inappropriate sexual contact to the Downers Grove Police Department. The victim's mother discovered alleged abuse after reviewing text messages on her son's phone. Well, initial charges filed back in March included 2 counts of aggravated criminal sexual abuse and 1 count of criminal sexual assault stemming from an alleged assault in a classroom during a tutoring session back in December of 2023. Further investigation, including interviews with the victim, revealed that the abuse began in January of 2023 and continued sometime up to September of 2024. Prosecutors alleged that Formello sent the victim multiple text messages describing a grooming in nature and engaged in approximately 50 sexual acts with him, including at least 45 incidents at the school, as well as the others at her home. Now, Formello was arrested back in April of this year during a traffic stop, which body cam footage captured her appearing quite confused and somewhat emotional during the arrest. She was taken into custody and could be heard sobbing in the police vehicle, expressing distress and asking for her husband. At a status hearing on Tuesday, the state filed a second petition denying Formello's pretrial release, which was denied by the judge. Her next court appearance is scheduled for August of 2025. Now, the state attorney praised the victim's courage in coming forward and acknowledging the efforts of the DuPage County Children's Advocacy Center and all the investigators that work on the team. The new allegations against Ms. Formello, including the allegations of grooming and that abuse lasted nearly 2 years, are beyond disturbing, the prosecutor said. Now, the investigation remains ongoing, with authorities continuing to review evidence related to the case. Seriously, Miss Formella looks like an attractive woman. You would seem to think that she'd be able, she's married, but yet she wanted to give everything up, including her freedom, for a high school boy? Something's not wired right in Miss Formella. Now, she's entitled to the presumption of innocence, but doesn't look good, does it? Anyway, next, a $1.4 million in Nintendo Switch 2 console stolen here in Colorado. So on June 8th, the Arapahoe County Sheriff's Office reported a major theft of 2,800 Nintendo Switch 2 consoles valued at $499 each, totaling $1.4 million. The theft occurred from a semi-truck trailer at a truck stop discovered during a pre-trip inspection by the driver en route from Nintendo's facility in Redmond, Washington to the GameStop in Grapevine, Texas. Now, the sheriff's office is uncertain whether the theft took place in Bennett, Colorado, or at another stop along the route. The driver was unaware of the trailer's contents, knowing only that it contained games or toys. Police are seeking suspects who could face charges of felony theft valued at $1 million or more. That's right, that would make it a Class 3 felony, looking at 4 to 12 years. Anyway, the Nintendo Switch, released globally back in June of this year, is Nintendo's most expensive console to date at $499 with the base model and the Mario Kart World Bundle. Pre-orders began in April, delayed due to Nintendo's evaluation of potential tariff impacts under new tariff laws, and Nintendo also announced price adjustments for 2 Switch accessories due to market conditions. Anyone with information may want to contact the Arapahoe County Sheriff's Department. Hey, who knows? Maybe it took place in Colorado. Maybe it took place somewhere between Washington and Colorado. But the reality of it is, good luck finding it. But hey, if you come across a smoking deal on a Switch 2 on eBay or something along those lines, and it sounds too good to be true, it's probably stolen. Just something to think about. Next, this day in legal history. On June 8th, 1878, Congress passed the Posse Comitatus Act. This law made it a felony to willfully use any part of the army to execute the laws except where expressly authorized by the Constitution or by an act Congress, right? Way back then, the Congress was aware of the concern of using the military for basic policing. They can't do that. Now, obviously, there are exceptions to that, but they're very limited indeed. Next, this date, 1778, British evacuations of Philadelphia spark legal issues. That's right. On June 18th, 1778, British troops evacuated Philadelphia during the Revolutionary War, prompting colonial authorities to address legal questions of property restitution and treason by loyalists, shaping the American legal framework. And then on June 18th, 1798, Congress passed the Naturalization Act, the first of 4 alien and sedition acts tightening naturalization rules and criminalizing false, scandalous, and malicious criticism of the government. On June 18th, 1936, Lucky Luciano is convicted on 62 counts of running a prostitution ring. The more things change, the more they stay the same, ladies and gentlemen. It's all the same stuff. June 18th, 1982, Georgia v. McCollum, decided by the United States Supreme Court. It bars criminal defendants from using race-based juror exclusions. Before, the prosecution couldn't do it. Now they're saying the defense couldn't do it either. Next, our legal quote of the day has the right to do with effective assistance of counsel. I thought that was appropriate, since obviously that's going to be the big issue today for the judge, and he's going to have to explain why he grants it or not. But more than likely, the reasoning will have to be, in the Bryan Kohberger matter, that is, effective assistance of counsel, which Bryan Kohberger is guaranteed. So the right to effective assistance of counsel is enshrined in the 6th Amendment to the United States Constitution, which guarantees that in all criminal prosecutions, the accused shall have the right to the assistance of counsel for their defense. A seminal legal quote articulating this standard for effective assistance of counsel comes from a Supreme Court case of Strickland v. Washington. It was decided in 1984. An accused is entitled to be assisted by an attorney, whether retained or appointed, who plays the role necessary to ensure that the trial is fair. The benchmark for judging any claim of ineffective must be whether counsel's conduct so undermined the proper functioning of the adversarial process that the trial cannot be relied on as having produced a just result. So this quote establishes the effective assistance requirements that counsel to perform in a manner that upholds the fairness and integrity of the adversarial process, with the Strickland test further requiring a defendant to show both deficient performance by counsel and prejudice resulting from that particular deficiency. That's why there were cases on death penalty cases where the counsel fell asleep in court or was drunk. They're like, well, yeah, I fell below the standard, but in light of the evidence, it was so overwhelming, wouldn't have made any difference anyway. So effective assistance counsel is a good way to get a continuance because then you constitutionalize the claim. But if you're going to fall on your sword, you better make sure that, well, you can back it up. I don't know what the judge will do today. If I was a betting man, I think he's going to say, no, you've had enough time. You're smart attorneys, done more than what most people would do given the amount of time that you had here. Let's move forward. And hey, if it gets reversed, so be it. We'll just come back and do it all over again. And finally, our dumb criminal of the day. A Texas judge fumes over farter faux pas. That's right. In a Jefferson County courtroom where felony charges hang heavy and decorum is king, one man dared to let his wardrobe break win, quite literally. Defendant Sammy Morris sauntered into Judge Raquel West's domain sporting a T-shirt proclaiming the world's best farter. The fine print, a cheeky, father, scribbled beneath, as if that could make the audacious stench of his satirical choices. Anyway, Judge West, a no-nonsense arbiter of justice, wasn't having it. With a stare that could curdle milk, she zeroed in on Morris, her voice dripping with incredulousness. What made you think that was a good shirt to wear to court this morning? She demanded, according to the footage from the courtroom there. The room no doubt held its breath. Morris, perhaps sensing the judicial storm brewing, mumbled a defense as flimsy as his shirt's cotton weave. It was, he claimed, the only shirt he could find. The only one in his entire closet. One can almost hear the collective eye roll from the courtroom gallery. That was the only shirt you had to wear in your closet? Judge West pressed, her tongue suggesting she's heard better excuses from a toddler caught with a cookie. Morris, now firmly in the hot seat, had no retort and salvaged his dignity or his fashion sense. This wasn't just a wardrobe malfunction. It was a masterclass in misjudgment. In a place where respect is woven into every Your Honor, Morris's T-shirt was a flatulent affront to propriety. Judge West's scolding serves as a reminder. In court, as in life, you'd better dress for the occasion or risk being called out for your gassy decisions. I had a client once wore a shirt that said, "You don't want to know what I'm thinking right now." Yep, that's right. We told him to turn it inside out, but that's what he showed up to court with. My other classic favorite was back in the day when marijuana was illegal. They would show up with a shirt with a big marijuana leaf. And the charge was always like, marijuana. Why'd you wear that shirt? It's all I could find, dude. Oh. Anyway, that's all we have for today, ladies and gentlemen. Remember, Karen Reed watch and the motions hearing for Bryan Kohberger right here. Watch it. We'll see you tomorrow. Remember, the Constitution matters.